right, the next case on the docket is MALAVE versus MALAVE.
I'd like to reserve 5 minutes for rebuttal, please. Police court. And may it please court, I appreciate the opportunity to be here. This is a fairly unique situation. It's a tragic situation.
Your name, sir?
Oh, William Roy.
Okay.
For the appellant. And may it please court, it's a very, very unique situation. In the middle of a divorce case, the husband had a very tragic car accident. Him and their 3 children passed away. It was a very public case. The issue before the court today is whether the trial court has jurisdiction retaining over the assets of the marital estate. In addition to the accident, what we have is a case where the husband, during the pendency of the divorce case, was conspired with, and these are allegations that are before the trial court, conspired with an attorney who's now been disbarred or suspended, and 2 other people to sequester and hide marital assets. Our client sought in the trial court to maintain an ancillary proceeding in Lake County Court and to go after those marital assets. The husband never filed a financial affidavit, even though he was under an order to compel to file a financial affidavit. He disregarded the court's orders, never did that.
I thought it was a motion to compel, no order had been entered.
You're correct, actually.
Okay, are you saying the statute requires him to file a financial affidavit?
No, what I'm saying is that it's a fraud in the court, that he was disregarding the court's.
How do we know that?
Those are allegations. All we'll really argue is jurisdiction at this point. The general rule is that the trial court loses personal jurisdiction in a divorce case.
There's a probate action commenced, correct?
Yes, in Polk County.
Right.
Yes, sir.
And why can't the action be brought in the probate court?
Because it was outside of the scope of the probate action. I was not the trial, I was co-counsel for the divorce action, not the probate action.
It really isn't about you, though. It's about...
No, sir. There was, in Polk County, to my knowledge, I don't think that was the proper forum to bring that.
Why not?
Did you feel that was the inappropriate division to bring it in?
No. I'm trying to think of the proper legal reasoning for why it should be brought in probate action. He's conspired with 3 other people, allegedly, to hide assets in the divorce case. So when he passed away, I don't know that there's an ancillary action for the personal representative to, our essential allegation was he stole $248,000 from his 401k.
Fraud, that he transferred assets fraudulently. Why couldn't the executor of the estate bring an action against those individuals to recoup the value of the assets fraudulently transferred?
Actually, Your Honor, the answer to that question is because it's not a probate asset. It was a 401k. It was $248,000 allegedly. It is not a probate asset.
Filing it in the general civil division.
The other co-conspirators were located in Palm Beach County and Monroe County. One of them defaulted, disappeared. Our essential argument is that the Lake County Court already has jurisdiction over the assets. We're arguing for a narrow exception to the rule that the court loses jurisdiction on the death of a party. The court has interim jurisdiction over the assets of a marital property when a divorce action is
Let
filed.
me ask you this. If we were to go with your position, what exactly are we accomplishing? Can the circuit court enter a judgment? What kind of a judgment would the circuit judge enter?
Well, we haven't got that far. All we're arguing is jurisdiction. At the end of the day, yes, the circuit judge has ancillary jurisdiction, has interim jurisdiction over the assets of the marital estate. When they filed for divorce, they had a pot of assets. Our allegations are, we never got to the part of proving him, is that...
Because he died,
Excuse me?
Because he died.
Yeah, he died.
All right, so where do we go from there?
The circuit judge, who already has the assets in front of him, should be the one...
To do what with them? That's what I'm trying to ask you. What does he do?
The same thing that a Palm Beach County judge would do.
It's sort of like the dog chasing the car. What is he going to do once he catches it?
Exactly. So why should our client have to go to Palm Beach County and file a new suit?
Why would you have to go to Palm Beach County?
That's where then you would lie with the alleged co-conspirator attorney.
Don't you have multiple defendants here,
Yes, I mean, one of them disappeared.
including the estate?
The estate is in Polk County, that probate's been done, and to address your question, most of the allegations lie around a 401K, which is not a probate asset, actually. That's the answer to why that's not, the probate court is not the proper court.
Where did the alleged fraud occur? Assuming there's fraud, where did it occur?
The marital home was in Lake County, and that's where the divorce action lies.
And that's the one that was...
The attorneys, the alleged co-conspirators,
The house was bought? Well, I guess it wasn't bought, okay. But if you have the cause of action, did some of the fraud occur in Lake County?
I don't know the answer to that, but no, I don't think so, and if that would be the case, then a civil suit would have been easier in Lake County than actually, as much as I enjoy arguing in front of you three gentlemen, that would be the easy course, but no. The answer is, there's no venue other than Palm Beach or Monroe County, which I think is where the other co-conspirator is alleged to be. And so our client would have to basically chase them down. Excuse me?
Where did he reside?
He lived in Lakeland in Polk County. That's where the probate lied. She lived in Lake County
He was employed where? Where was,
in Lake County.
Lake County? The 401K, the assets were in Lake County?
No, actually, those were in Hillsborough County.
So if all the defendants here and all the assets and all lay in Lake County, you'd be fine with going to circuit court? But
Absolutely. If everybody lied in Lake County,
so your argument, your appeal is really about...
Our appeal is really-
Where you'd get the venue you preferred.
it's a matter of equity, Your Honor. Why should and I don't want to tear the heartstrings, but she just lost her semi-ex-husband and 3 children in a car accident. He was conspiring, allegedly, and based on our allegations that we can actually prove, but we've not gotten there. Based on those allegations, though, he conspired with an attorney who...
You're coming to us and arguing equity. Is that what you're
Exactly,
saying?
yes. It is totally a matter of equity. The circuit court is a matter...
That's what you view our role as a court of
No,
equity?
actually, I view, we're arguing for an extension of the general rule, and that's why the circuit court dismissed this case, is that on the death of a party in a divorce action, the court loses personal jurisdiction. We don't dispute that. What we think is that, and what we're arguing for, and this is a case of first impression, actually, on the appellate courts, is that the court retains in rem jurisdiction over the assets. And that's all we're asking for.
Well, the court only has jurisdiction over the assets because there's an ongoing divorce, correct?
Yes, that's how original jurisdiction under the statutes is gained, but there are many, in our brief, we've cited many cases that show that the court maintains jurisdiction over the assets.
Okay, but are any of those...
Why should our-
Do any of those cases involve a situation where there has not been a final judgment?
There is not one case that deals with this situation, and that's why I said this is a case of first impression. This is a unique factual situation, and we're asking the court for a very narrow exception to the rule that says that the court would lose jurisdiction over the case on the death of a party.
Let me ask you a question going backwards. You indicated you were co-counsel on the original dissolution of marriage?
Yes, my father was the main counsel in that.
In Lake County, and I didn't see this in either your brief or opposing counsel's brief, is there a standing family law order in that county?
Yes, sir, there is.
Okay, and that wasn't raised?
Yes, sir, it was. That was on the motion to compel. There's a standing order to freeze everything.
So it was premised based upon the standing family law order?
Yes, sir.
Okay, and that's an administrative order, or is that one that is placed in each individual?
I believe it's an administrative order in all divorce cases in Lake County.
Okay.
In the 5th Judicial Circuit.
That's all I need to know.
Basically, what we're arguing is that the circuit court in Lake County that had personal jurisdiction over everybody should have the jurisdiction to put everybody back in the situation where they started. We're not arguing for a massive extension of current law. We're arguing for an exception to the rule that says, in general, the circuit court loses jurisdiction on the death of a party. The circuit court does not lose jurisdiction over the assets on the death of a party. And the circuit...
First, though, what happens next? Let's assume for a moment that everyone gets put back in your case on the day before he passed away or a week before he passed away. Then what happens next? What is the trial judge to do?
Assuming we prove our allegations that he transferred $248,000 out of his 401k in violation of the standing order to freeze all assets.
And who would be the other side at that point?
That's the appellees, actually. Herbert Biggs and Shy, I don't know what the other guy's name is. He's been defaulted. He's not shown up.
Mr. Chavon?
Biggs is, yeah, Chavon. Biggs is the main guy. He was an attorney. Our allegations are that he was in cahoots with the husband in this. And they essentially made fraudulent real estate contracts. Those allegations haven't even gotten to the trial court.
Let's keep going. Let's assume that you prevail then.
The trial court could enter a judgment, a money judgment, against Mr. Biggs.
Again, Mr. Biggs, based upon, what happens to the assets of the decedent and the...
If he transferred marital assets to try and conceal them, why shouldn't the court that is trying the divorce case that had jurisdiction over that be able to govern those assets?
It sounds to me like you're asking for the dissolution of marriage judge to become a probate judge.
It's not a probate asset, though. That's the thing. It's a very... A 401k is not a probate asset.
Are you saying that the assets that are not going to the probate court should...
The probate has been totally administered. That's all done. A 401k is not a probate asset. The probate court does not have jurisdiction over a 401k.
So is that the only asset...
It's a matter of contract law, actually.
Is that the only asset that should go back?
That is the main one. That is a $248,000 allegation. There are other assets that were non-probate assets as well. But essentially...
Under your theory, where is that money?
Excuse me?
Under your theory, assuming that your allegations is true, that he has a fault, this fake contract to buy, presents it to the administrator of the 401k that's, buying a house for homestead, so they release the money to him, and then what happens to the money? Does Biggs have the money?
Yes, sir. And, that's why he has been recently suspended, or I think suspended for 5 years for similar allegations. I don't know the exact construct of the fraud. What our argument is that the trial court that already has jurisdiction...
Have you traced the $248,000 to see where it's at?
Actually, yes. It's a series of fraudulent contracts and flip houses. Yes, we have traced that. Under current law, our client has to run down to Palm Beach County, which is not close. She's from Lake County. She lives in Lake County. Well, actually, she lives in Atlanta now, but... And there's no reason to start a fresh new case down there. I believe that what we're asking for, that a very narrow exception we're asking for to the rule that says the court loses jurisdiction on the death of a party All we're asking for is a very narrow exception that says,
The trial judge here held no hearings.
this, that's incorrect. I was at the hearings, Your Honor.
There were no hearings held in this case because it was
There were-
relatively new. The hearing on the motion to compel was canceled at least once, or maybe twice, is that correct?
In the divorce case, in the ancillary actions, there were hearings held. I was at those hearings.
I'm talking in the divorce case.
In the divorce case, no, it never got that far.
Okay, but you're saying this judge who held no hearings in the divorce case should take jurisdiction over the ancillary action and then deal with it here?
Judge Hill originally granted the action, see him down in 4 minutes, I'm going to reserve 2 minutes, so I don't think I need much rebuttal, but Judge Hill originally granted the ancillary action, and then on the motion to dismiss is where we got into the tight rule that on the death of party, the court loses jurisdiction. All we're saying is that the court still has jurisdiction over the assets. We're not asking for a divorce. We're not asking for any kind of personal jurisdiction. All we're saying is that this is a case of first impression. The court has not seen, the appellate courts have not seen fit to rule on this narrow of an issue. And I appreciate the opportunity to argue it in front of you all.
Thank you.
I'm going to reserve my last 4 minutes for rebuttal, and may it please the court, and I thank you for the opportunity.
Good morning. May it please the court, Nicole Siegel from Burlington and Rockenbach on behalf of the appellee, Herbert Biggs. I'd like to start off by saying that the general rule here has been presented as being that a family law court loses jurisdiction after the death of a party. That is the general rule, but over time that has been refined, and as the Supreme Court explained in Gaines, it is a substantive rule of law that renders ineffective a divorce decree and divests the course of jurisdiction over dissolution proceedings where one of the parties dies before a final judgment has been entered. Here, the husband died long before there was any final decree as to the marriage or the property, which I think you all have recognized.
Let me ask you this.
Yes.
The ancillary petition alleged fraudulent transfers by the now deceased husband.
Yes.
All right. And that could be brought in a civil action.
Correct.
And we don't know yet. The venue issues aren't before us. I mean, arguably it could have been filed in Lake County.
Correct.
Rather than dismiss it, is there any reason the trial judge could not have just transferred the petition to the general civil division in Lake County? And then if you wanted to file your motion to dismiss on venue or whatever, that's a separate issue. We don't have that before us. But why would the trial judge be obligated to dismiss it as opposed to just transfer it to the proper division?
Because I don't necessarily know, I mean, and obviously, as you mentioned, this wasn't something that was really addressed, but Mr. Biggs lives in, I think his office is in Palm Beach County. As a defendant, he would have been entitled to have an action brought there, or where the cause of action accrued. There are other issues, but I don't necessarily know that would have been improper to transfer this action, which the trial court didn't have jurisdiction over anymore. Arguably, that includes transferring the case. The case would still be open. It would be transferred to a different division, but obviously, Mr. Biggs could probably argue venue.
There was an ancillary petition filed.
Correct.
Okay, so arguably it got filed in the wrong division because it got filed in a family law case, and if the family division no longer had jurisdiction over that, then it should have been filed elsewhere.
Correct.
All right, so if you file an action in the wrong division, isn't the normal remedy just to transfer it to the correct division rather than dismissing it?
This was the existing case. It was the family law case. So I understand the practicalities of what you're saying, but that would still be the family law case being moved over to another division.
It's the ancillary petition that's being...
Excuse me, the ancillary petition.
Family law case.
Well, it was being brought within the family law proceeding. I mean, it was under the same case.
Petition that would...
Correct.
Are you saying that that ancillary petition can be brought someplace else?
It could have been, I guess our point is that a separate action should have been brought.
I thought the order of dismissal said with prejudice.
It did.
And one. Does that mean that she can run now someplace else and file when your client now has this order of dismissal says with prejudice?
Yes, because the dismissal was based upon that court not having jurisdiction anymore, not...
Is that what that means? Because I couldn't discern the meaning of...
That's what I would take it to mean, and I don't think there was ever any objection. I mean, our position all along was that they could bring this action in a separate action, and they never argued, hey, we couldn't bring it. I don't know of any reason why the with prejudice, when it was based upon jurisdictional issues, couldn't have been brought.
There's no argument made that the ancillary petition didn't properly set forth the cause of action. The only thing that's gotten raised at this point is that it was brought in the DR division.
No, there was, I believe, an argument, and again, this wasn't specifically what was addressed to the trial court, but I believe that there was an argument in the motion to dismiss the ancillary petition that for merits reasons.
Was it ruled upon?
No. The trial court addressed the jurisdiction issues and said, I don't have jurisdiction over this case anymore, which is proper under the case law. Unless there are any other questions on that, I'd like to address something that Judge Zambrano raised. And what you said is really the heart of the matter here is you get the cases in the family law court and you allow the court to hear this petition and just get these assets and bring it back, but what's the court going to do with it? And that is a problem here. The allegations are this $248,000 was taken out of the 401k, but what they've alleged in the ancillary petition is that this money was then purchased personal property, it was given to various people to kind of hide it and move it around, it purchased cars, I believe. There's all kinds of allegations in the ancillary petition as to what was done with all of this money. Now, all of that, I think...
Doesn't that leave the wife in this case without an ability to recover some of that stuff?
No, and what I think is important is that she could have gone to the probate court. And this, I think, interferes with the probate courts.
A lot of these assets don't go past a probate court. Life insurance policy, in this case a 401k, I'm trying to think in a broader scope, Even some residences that you may buy with your friends and, have rights of survivorship, totally skip the probate court.
Well, the life insurance is separate. I don't think that was an issue as to Mr. Biggs. I think the two, and what even was presented here, is that it had to do with the 401k. The 401k was apparently cashed out and bought all of this personal property. All of this personal property, the probate court's going to get this case, and I don't know what happened in the probate proceedings, but those were technically, theoretically, at least at the beginning, probate assets, because they're personal property. Some specific asset may not, but all of that should have been dealt with in the probate proceeding.
Well,
if the probate court decides that any specific asset, then you go and file a separate action in a general court.
So she has to sue people all over the state if that's what husband decided to do, to make her life as miserable as possible.
I obviously don't agree with whatever, if that is in fact what happened, and I don't want her, obviously we don't want her to have to go all over the state, but our defendant, he has his rights, and he has the right to have the action brought. If he's going to have a specific action brought against him, it has to be brought in a specific location, or it should be brought in the probate proceedings, because I think that there's going to be an issue of conflicts between if another court, or even the family court, is trying to deal with assets and find all this money that has maybe been addressed in the probate court or not addressed in the probate court, but there's going to be a lot of overlap since the allegations that they've alleged are that all of this stuff bought personal or real property.
Let me skip up a little farther. Also, there was a claim for attorney's fees under 57105. Do you think that was improper to be heard in this particular
that was
setting, meaning because it ties to the dissolution of marriage, or that's the allegation? The case got dismissed before it got past the pleading stage.
Exactly, Your Honor. That was brought in the ancillary petition, which was brought after the court had dismissed the case, after the death of the party. That's all part and parcel of the ancillary petition not being permitted. If she wants to bring a claim for 57105 fees, that could have been brought in any other action. It could have been brought...
You're saying there is an independent cause of action under 57105 that could have been filed in West Palm Beach?
No, Your Honor. I'm saying if she somehow objects to his position with regards to this money or actions that he took, but I don't think that the circuit court had jurisdiction, the family law court had jurisdiction to entertain and that is clear from the case law, and I can give you the cites in just a moment, but to address an attorney's fees request which was filed after the death of the party, where the court had lost jurisdiction. And there is...
Before the death of the party, black letter law says, yeah, that's one thing that survives.
Exactly. That is one, and I would say that's really the only example from any of these cases that if an attorney's fees request has been made by the decedent before final judgment or decree has been entered, the court can entertain that later. But there's no case law that someone can file an ancillary petition after the case has been dismissed, after the death of the party, and try to get 57-105 fees or any attorney's fees from someone who was not even a party to the original action.
Even when the claim for attorney's fees is premised on fraud, you're saying that still shouldn't happen?
I agree, and I think it's important to note here that this wasn't, as it was alleged, this wasn't necessarily a fraud.
The allegations, I'm just speaking...
No, I know the allegation. I mean, the allegations were that they fraudulently convinced the administrator to get the money out of the 401k. This wasn't an allegation that Mr. Biggs came into the court and said that he had not, they hadn't moved any assets. This wasn't a violation of any order. There wasn't an actual filing of a financial affidavit that stated that these assets were not, his anymore, that he didn't have these assets. So it wasn't necessarily even a fraud within the family law proceedings. It was a fraudulent, attempt, and I guess it's apparently, according to the allegations, a successful attempt to get the money out of the 401k. And I think that's important because, again, that can be brought elsewhere. That is not necessarily an issue which can be brought within the family law proceeding, which already the court didn't have jurisdiction over.
I would argue it would be it's marital.
Yes, no, I agree with that, Your Honor. Let me see if there's anything else that I wanted to address.
I probably threw you off your horse there.
Oh, no, I understand that. I mean, I understand, but I just don't know of any reason why an attorney's fees motion filed after, and there's no case law, and the case law is actually directly contrary.
I kind of agree with you there, with one minor exception, is the fraud aspect of this is really troublesome, because it seems like, in this case, your client, Mr. Biggs, could benefit from the fact that his client died, despite the fact that there was all this fraudulent activity going on right up until the time he passed away.
I certainly understand your concern, and I anticipated that when I was going through. I thought the court, I understand. If he had come in and sort of affirmatively told the court these assets don't exist or he's never had all this money, but that's not what happened here. And what happened here, even according to the allegations of the ancillary petition, I'm pointing over there where I have it sitting, but all of this money, I don't believe there's any allegation that he actually has any of the money. All the allegations were that the money got taken out, put into various personal, and I think maybe some real property, some cars, and
He might not have
put in other
but
people's...
the allegation is that he conspired to accomplish those ends.
Correct, but with regards...
The fact that he might have benefited simply in the terms of being paid a fee, I don't know that that's relevant one way or the other.
I understand, and I understand that, but I think that it's also, I think the important part here is that really that this all happened. Really what I think now is, it comes down practically, and as I pointed out earlier, is that these were all converted into assets which theoretically were probably addressed, or should have been addressed, in a probate proceeding. This was all personal property. He bought cars. All of that would be probate assets. There's no more 401k. So that's, while we say, well, that's not a probate asset, well, there isn't any money in the 401k anymore. So now we've got all this personal property, which theoretically should have been itemized and listed by the personal representative. And if somebody wants to come in, if the wife wants to come in and say, well, really, those assets should all be mine, and I don't even know if there was a will or if this was intestate, but I'm sorry.
Who was the personal representative?
I don't know, honestly. That wasn't part of this proceeding. So I would imagine she could have dealt with all this in the probate proceeding. This was all, as she's alleged, all of this was transferred into personal property.
When he gets up for rebuttal, you feel free to chime in anytime you want.
Okay. And I think that is all that I have. Unless there are any further questions, I will ask that you affirm the orders on appeal, as there was no jurisdiction of the court to...
Before you sit down, I'm going backwards now to... Is there really no remedy for, this is not an uncommon situation, the death of one of the parties before a judgment, sadly in domestic cases, is not an unusual occurrence. And when you have a fact scenario such as this, where there's a massive dissipation of marital assets, or the allegation of massive dissipation of marital assets, where there is a standing family court order that says no one is allowed to do that. And prior to judgment, the wife is totally oblivious of the fact that this is going on. You're saying there's no remedy for that other than to go sue and chase the money, and chase the assets, whatever they may be, and file suit in those individual places. Is that your position? Just to make sure I understand it.
It's not exactly. I think this all could have been dealt with in the probate action. Probate courts often decide this asset is not a marital asset. The 401k here is not a marital asset, an estate asset. So that's going to be dealt with separately.
But not all of it, some of it.
Exactly, but that's the purpose of that whole proceeding, and especially if she's the personal representative. I just think that in this case, and I agree, it probably is common, and there's lots of cases that we've both cited. None of them have to do with a death before a final decree. And I think that this probably does happen. And the proceedings there, the issues are then resolved either in probate or in independent actions, which is why we don't see this. I mean, the law is very well established that if there hasn't been a decree entered, then the family court loses jurisdiction, except in that limited issue of the attorney's fees requested by the decedent before the decree, which has been allowed. And so I think that this probably has happened. And it probably isn't. While it's been addressed as an issue of first impression, the law is very clear. And so I think that possibly what happens is that people then go take this into probate, or then if to whatever degree that probate court can't handle it, then you deal with that separately. But I don't know that it would be appropriate, and would probably interfere with the probate court's actions to have this separate family law case where the decedent's assets are being dealt with and pulled in and determined, what happened to these assets and where they are. And again, that goes to your question earlier to opposing counsel, is what does the family court do with this? I mean, obviously there's a question of the fraud aspect of it, but okay, you decide there was a fraud and they fraudulently took this money out. What do you do now? All the money is in...
adjudicate whether or not the wife has a vested interest on some of these assets? Put her in priority ahead of everybody else who received a fraudulent transfer?
I mean, I think that's something...
Couldn't that be adjudged by the...
I don't think so.
I'm reaching, by the way.
I don't think that the court has jurisdiction to do that, and I think that that is exactly something that could happen in the probate court. If there are specific assets where title is in question, then that is certainly often dealt with, I would imagine. You hear it more in these cases of, guardians who take advantage of elderly people, but property getting transferred fraudulently from somebody to somebody else before the death, and that is dealt with. And that is dealt with in the probate court. The personal representative has authority to bring actions against other people, to bring back in, I guess, claw back, for lack of a better term, any assets that should be in the probate estate. And all of that can be dealt with there. And all of it should be dealt in one centralized location, or one centralized action and one centralized court. To have two different courts trying to figure out the assets and determine where they are and whether they're marital. I mean, actually, even the phrase marital assets assumes that these are marital, that there's going to be an equitable distribution, which it's not the case anymore. These are probate assets. These are estate assets. And all of that should be dealt with first in the probate court, and any separate actions can be brought.
One more question.
Yes, Your Honor.
The initial order that the judge signed, the trial judge signed, indicated that he was placing everybody on notice that the estate of the decedent, in this case, was not to transfer any or all of the respondent's assets of this divorce action, and to hold the same for distribution in the appropriate probate court. So that's the original order.
Which, was that when she first...
That was the January 28th order.
That was the order right after the death, okay.
Right, so couldn't it be fair to say that this judge was concerned about the dissipation of assets subsequent to the death of the husband in this case?
it sounds like it, and that's,
Should there have been some dissipation of assets by your client, Mr. Biggs, subsequent to the entry of this order? Do you believe that then a cause of action, and ancillary cause of action would exist with this judge in this court?
you know, I'm not sure. I think possibly it could. You know, I don't know, actually. I don't think that it could. Again, the jurisdiction isn't there. But if the order had specifically said that you can't move any money in that, you know, Mr. Biggs himself, I mean, I can't answer that honestly right offhand. I wouldn't feel comfortable.
All right, thank you.
Thank
Thank you,
you.
Counsel.
And I again ask that you affirm the orders on appeal. Thank you.
All right, you have just over 4 minutes.
Thank you, Your Honors. Just a few brief things. Number one, I'd just like to point out that the circuit court, as we all know, is a court of general jurisdiction. That is the trial court that is general jurisdiction. The law was made about what division it was in, family law. That's really a matter for the clerk and administrative. The circuit court by statute is a court of general jurisdiction, whether it's family law. That family law jurisdiction is derived by statute under, I believe, 61, whatever it is. I don't claim to be an expert in divorce law, but I do know quite a bit about probate, and as far as...
Well, just administrative duties of the clerk. For instance, what rules of civil procedure apply?
The Florida family law rules of procedure
Right, but if
apply.
it's an independent, but if it's in the civil division as an action to recover assets on a fraudulent conveyance, then the family rules of procedure wouldn't apply.
You know what?
It's more than just an administrative issue, or which judge in the, you know, whether it's this judge on the second floor or this judge on the third floor that hears the case. I mean, there's more than that involved.
While that's true, the circuit court is still the court of general jurisdiction in the state of Florida. So...
So what rules of procedure apply if we accept your argument?
You know what, both, it tends to be a hybrid, and we actually did make a 12.540 argument in this case. I didn't bring that to the court's attention because I don't find that to be a very strong argument. It's the fraud exception to...
Okay, but if we agree with your argument and said, you know, continue the case, the verified petition, the ancillary petition, continue it in the, you know, front of the dissolution of marriage judge, what rules of procedure apply?
In that case, in the ancillary petition, I would say the general rules of civil procedure apply. All we're asking for is to put everybody back in the position they were in when the case started. We're not asking to jump 10 leaps. What we're saying is that we shouldn't have to go running around to be put back in the same position that our client was in when she filed for divorce. We're asking for a very limited exception to that. And the circuit court is the right place to hear that. The circuit court of Lake County had jurisdiction over the divorce action when it was filed. There was no question raised about that. So the circuit court retained jurisdiction over those assets. And there was, when counsel was up here, and I understand how it went, a 401k is a matter of contract between the decedent and the person, the company. It is not a probate asset. It is not subject to probate rules. But it is subject to the standing order, as Judge Zambrano...
Well, we don't know if it's entirely a marital asset, do we? I mean, we don't know when the 401k was open and
That's the thing, we never got to that point in the trial court. We never got to litigate those issues. All we're saying is, the court should have jurisdiction. Excuse me, sorry.
Because I think one of the houses was bought by the husband before the marriage, right?
I don't know the ins and outs of the actual asset transfers, Your Honor.
Right, so it could be that some of that 401k was premarital.
It could be. The allegation is that it was a marital asset, and before this court, what we're saying, this is a jurisdiction issue. We're not trying to litigate the ins and outs of the transfers before this court. The honors have better things to do than that. What we're saying is that there's a limited exception that the court should have in rem jurisdiction over those assets, and it's judicial economy. It's more efficient that the trial court have jurisdiction over the assets that already had jurisdiction over.
I mean, I still don't get over the fact that there's got to be somebody on the other side, and in this case, if somebody on the other side is dead, you're saying the personal representative should step in. I'm having trouble with that.
I have 17 seconds left, but I will say that the probate case was fully litigated. There's somebody on the other side, for client, Mr. Biggs. There is somebody on the other side. There's a defendant in this case.
Well, not somebody on the other side who has an interest in, a vested interest in the property from the outset of the filing of the dissolution of marriage, which was a husband. You know, the allegations are he dissipated the asset and handed it to Mr. Biggs and whoever else, his mom, his dad, and the rest of the world. But if these assets come back,
The rule we'd ask the court for is just that the court have jurisdiction to keep those assets the same as they were when the divorce action started.
All right, thank you, Counsel.
Thank you. Your Honor.
All right, we'll be in recess.